Tonight, back on the stand.
Courtroom calls Jennifer McCabe.
A key figure from the first trial returns for round 2.
He never came in the house, and she doesn't know where he is, so now where could he be?
What Jennifer McCabe had to say about the final moments of John O'Keefe's life. Plus,
so you didn't even raise yesterday in your presentation about where the phone might be located. You didn't even raise the experiments that you did, correct?
the reliability of forensics called into question as the temperature of a cell phone battery becomes a main focus. Canton Confidential, the Karen Reed murder trial, starts right now.
We had our first full day of testimony as we settle into the trial's second week. Good evening, everyone. I'm J.C. Monahan.
And I'm Glenn Jones. Cell phones were once again a hot topic, but also highly anticipated testimony from a woman who helped find John O'Keefe's body. Our Melody Mendez joins us live from outside Norfolk Superior Court in Denham. So, Mel, bring us up to speed on the day's developments.
Okay, well, Glenn and JC, we heard again from that digital forensics expert that we started to hear from yesterday. He was back on the stand. He was the one that was tasked with extracting the data from John O'Keefe and Jennifer McCabe's cell phone. Now, yesterday, when he was on the stand, he drew a very clear and concise picture of what John O'Keefe's final hours likely looked like based on the data that he had taken from his phone. But today, same man on the stand, this time under cross-examination by attorney Bob Alessi, and that same data painted a slightly different picture. Take a look. Back on the stand in the Karen Reed murder trial, Ian Whiffen, the digital forensics expert, cross-examined by the defense, who tried to poke holes in what the prosecution says happened to John O'Keefe. Whiffen was asked about his testimony regarding location data on John O'Keefe's phone yesterday, saying the night he was killed, his phone never left the area of the flagpole where his body was found. The prosecution was trying to use Whiffen's testimony to show that O'Keefe never went into the home after getting out of Reed's SUV. But today, Alessi brought up another report done by Whiffen.
It is difficult to say with any degree of certainty if the device actually moved. Did I read that correctly?
You did. Monday, the witness showed the jury this satellite picture of 34 Fairview with dots around the flagpole to show where he says the phone was all night. But during cross, Alessi pulled up another satellite image left out of Whiffen's presentation to the jury, showing a much wider radius where the phone could have been, which includes a large portion of the home.
You did not include that depiction in your timeline that you discussed with the jury yesterday, did you?
I did not know. When pressed, Whiffen admitted that based on that photograph, the phone could have been inside the house.
According to your report, the phone of John O'Keefe could be in the house, correct?
Based on the low accuracy information, yes.
The answer is yes.
Yes.
Keep in mind, the home was never checked by police who responded that morning. Finally, attorney Alessi narrowed in on Whiffen's testimony about the timing of Jennifer McCabe's Google search, "Hoslong to die in cold." The defense claiming it happened at the time of the timestamp on the phone, 2:27 a.m., before O'Keefe's body was found. Whiffen saying it actually happened after 6 a.m., but registered at 2:27 because that's when she initially opened the browser tab.
I want to be fair to you because
All right, so when Whiffen was done on the stand, Jennifer McCabe took the stand. She is, of course, a key witness in this case, and she'll be back on the stand tomorrow. Glenn and JC, back to you.
All right, Melanie, so this testimony from Jen McCabe was so anticipated last time. It was certainly the case today. So far, only direct examination. Anything stand out?
Right. No, Glenn, you know, it's a valid question, and I think it was so similar. It is so similar. At least the words she was speaking. There were differences in other contexts, but the words she was speaking were very similar to what we saw in the first trial. She talked about her relationship with John O'Keefe, her relationship with Karen Reed, and her memory the night before John's body was found and then the morning of. But we'll, of course, see more of that testimony and see her under cross-examination. Not certain if that'll start tomorrow, but presumably so, depending on how long direct questioning takes. Guys, back to you.
Melody, thank you. Now back with us tonight is Florida-based attorney Peter Tragos. He's been following the case on his YouTube channel, The Lawyer You Know. Welcome back, Peter. Round 2 of the trial. Let's begin with Jennifer McCabe's testimony. First, we're going to take a listen to some of what she had to say this afternoon.
she would go from sitting back to leaning up in between us, and she would yell Kerry's name 3 times. Then she would yell my name's three times. And then she would yell, could I hit him? Did I hit him? Over and over again.
Okay, Peter, her testimony was a major part of the first trial. She was only on the stand for what, about an hour and a half or so today. She'll be back tomorrow. But so far, what's your reaction to her testimony?
I think she presented well. I think the direct examination is going well so far. I think she's likable. I think she seems like great friends with John O'Keefe. Doesn't seem like someone who would want to hurt John O'Keefe. For the Commonwealth's point of view, she's making sure to get in all the details they need. I hit him. Could I have hit him? The cracked, broken taillight. She thought John and Karen Reed could have gotten into a fight that night. And she even said, Carrie Roberts said, you were so drunk, Karen, you could have hit anything, which I thought was inappropriate to come in, but the judge allowed it. So she's definitely getting her licks on the defense during direct examination.
McCabe's fiery exchanges with defense attorney Alan Jackson were some of the most memorable moments from the first trial. We certainly talked about it here. Let's give our viewers a reminder of what unfolded in trial number 1.
I never would have left John O'Keefe out in the cold to die because he was my friend that I loved. She was screaming frantically in the back seat and texting in the back seat.
Was she just sitting there, curled up in the back seat, sucking her thumb, or was she searching out the window?
She was screaming between Kerry and I.
That trip, Ms. McCabe, to search for John?
It was because she knew where he was.
Would you have stopped? And your answer was what?
What was the direct question?
Oh, my goodness, Ms. McCabe. It was 5 minutes ago.
Right. Did he ask, did you see something? You like to change words. I just want to be certain.
Peter, there was a lot of animosity there. If we take the Google search, maybe it didn't happen at 227. We know from the Canton police audit there was no conspiracy found, as they reported, and the federal investigation is over. Does Jackson have a little less to work with this time when he cross-examines this witness?
Not at all. I don't think the audit or the federal investigation have anything to do with Alan Jackson's cross. I think he's going to still point to the conspiracy. I think the defense absolutely still believes there was a conspiracy and is at least trying to prove it in the vein of a reasonable doubt or another possibility of what happened that is reasonable. I think they will still go hard at Jen McCabe, and that's why direct is going well. But we all know it's a completely different story on cross-examination throughout this entire trial.
Peter, can we go back to the back and forth about the technical data today? I mean, if you don't like technical data, then this was just a mind-blowing thing. Is there enough, based on what happened today, for the jury to consider reasonable doubt?
I think the answer is probably yes there, but the way I look at it is it's not necessarily that the Commonwealth's case is providing reasonable doubt, are they getting rid of it? Are they proving this case? And I think during the cross, we found out just how inaccurate some of the location data can be, how even Mr. Whiffen sees some inaccuracies or some problems with the hash value and all the technical things that he's testifying about. So maybe it just wasn't as strong as evidence as the Commonwealth hoped. I'm not sure that it proved reasonable doubt, although Alessi did get the witness to say on the stand, is that a doubt? Yes. And is that reasonable? Yes.
All right, so we knew the technical data that JC was just talking about was coming because prosecutor Hank Brennan promised it in his opening statements. So now we saw some of that play out. I'm wondering if you think he delivered on his promises. But first, let's watch what he told the jury to start the trial.
Remarkably, it will be an expert in this case who found the data file on the phone, and it tracks the temperature of the cell phone battery. That will be critical to your analysis in this case, the temperature of the cell phone battery.
He has certainly found an interesting way, Peter, to make the cell phone battery temperature weave into the story he needs the jury to believe.
Yeah, that's a great question. And that's a great clip from opening because the data and the science is with the Commonwealth and is going to prove this case. And we'll see if it ends up happening. But what I got from Mr. Whiffen's testimony is the least convincing thing was the cell phone temperature. He didn't even know what freezing was in Fahrenheit. He was doing these examinations, not knowing whether the phone was in the case, in a pocket. He didn't know what the temperature was outside that night. He even told us he really couldn't get anything from his own experiments except that the cell phone temperature is changing as the cell phone is in different environments. It went up and down in different degrees in his test versus what it did outside. The defense pointed that out. I got almost nothing from the cell phone temperature changing. I thought the location data and the steps were better for the Commonwealth than the temperature change.
So we're running out of time, Peter, but overall, I mean, I know we're early on, but today, a good day for the prosecution or not?
There are good parts every day, right? I don't think it was a home run. I don't think it was a great day overall. There were definitely good parts. I think the presentation is tighter, more understandable. It is more connected than last time. And I think the jury's picking up what the prosecution's putting down better in trial 2 than they were in trial 1 at this point.
Well, it's clear you're more impressed with the effort by the Commonwealth this time around than you were last time. So we'll see where that all ends. Peter Tragos, thank you so much. We always enjoy having you.
Thank you.
Our courtroom insider, Sue O'Connell, joins us now. She's been posting on X throughout the trial. We were in the courtroom again today. So this was the first time we saw McCabe this time around. Does her presence create a vibe around and in the courtroom in the same way it seems to do on the internet?
So it's interesting because you have to imagine that the jurors were picked because either they have an open mind or they don't know that much about the case, right? So we build up Jen McCabe, but we don't know what they do or do not know, right? And she gets on the stand, and of course the press is paying attention. People in the courtroom were there. She had some family members there. There's a little bit more security presence there. And then she gets up, and she is a basketball mom who shuttles kids around from Canton and portrays herself that way. That's actually who she is. She's got an edge to her because she's a greater Boston chick, right? And you could see members of the jury connecting with her around certain things. Now, that leads us to believe they may not know what's coming tomorrow or the day after on the cross. They may not know what this Haas Long has to do with her in terms of the connection to whatever the defense is going to bring forward. But when she got up there, I think we had one witness before her, John O'Keefe's friend, who was a human and not an expert. She was the first person up there for a long time who was just a regular person sharing her experience, and she connected with the jury today.
The way I took it in, though, I understood the way Brennan laid it out. I understood better what happened that morning, the way she described it, and I'm following everything. But it seemed really clear, and the other takeaway I had was her demeanor and her presentation just felt different, much like she said, I'm a basketball mom. It just had a softness to it that when she was on the stand the first time we played a clip, now granted it was on cross, but she definitely had a much more aggressive presentation. But did I read that right? It's similar to how you read it in the courtroom?
Yeah, absolutely. I mean, we saw from the first trial, she thinks Karen is guilty. I mean, it's not like there's any room here. She thinks Karen killed one of her best friends. So, like I said, I can relate to Jen McCabe in a way. I'm a girl from Revere, and I think I would get up being a little tough-edged if I were on direct examination, and even harder on cross. But I imagine she learned from the first trial and decided to just, buffer the edges a little bit. But, when Alan Jackson and she get up there head-to-head, I think we're going to see some fireworks.
Yeah, I agree with that.
That could happen tomorrow. Sue O'Connell, thank you very much.
All right, don't go anywhere. We're back with more Canton Confidential, the Karen Reed murder trial.
Up next, a huge ruling about whether crash reconstruction experts will be allowed to testify for the defense. 2 members of ARCCA were questioned by the prosecution at a hearing yesterday. After the break, Judge Cannone's ruling. Plus, we're answering viewer questions. All of that when we come back.
Don't miss any of the Karen Reed murder trial. Get the full recap of what happened in court, expert analysis, and what we could see next. This is coverage you won't see anywhere else. Canton Confidential, weeknights at 7 on NBC 10 Boston.
I understand there have been repeated violations of the reciprocal discovery orders and my orders, repeated and deliberate. However, a defendant's right to a fair trial is paramount to everything. That's where we stand, and I expect counsel to comply with all rulings and rules of the court and all rules of professional conduct, and no more nonsense. Let's just try this case.
With that ruling, the ARCCA experts will be testifying in Karen Reed's retrial. Welcome back. We're joined now by attorney William Kickham, along with Sue O'Connell, who stayed with us. So welcome to Canton Confidential, the Karen Reed murder trial. It's good to have you here. All right, so ARCCA is obviously a key part of the defense's strategy in this retrial. Are you surprised at the judge's ruling, especially because she seems so exasperated by this whole process?
I'm not surprised, and her ruling reflects a saying in the law, which is that the prosecution's evidence that it offered concerning ARCCA's, misdeeds, I'm going to use that loosely, okay? Right. That evidence outweighed its prejudicial effect. In other words, if a body of evidence is probative evidence, but the probative evidence outweighs the prejudicial effect, it will be still allowed in, and that's what Judge Cannone did with this. There was some evidence that maybe everything wasn't followed to the letter concerning ARCCA's communications with the defense, but ARCCA's testimony is so crucial to the defendant's defense that she's allowing it in, because anything to the contrary would outweigh its prejudicial effect.
Well, we talked so much about ARCCA. I'm sort of like, now we can just sort of cross that off the list and wait for them to take the stand. Can we talk about the number of sidebars that we've had? Yeah. Because it does seem like they're happening a lot. I mean, you have the prosecution calling for them to defend. You have Judge Cannone saying, time out, I want a sidebar. Is this a typical? And then, Bill, after you talk, Sue, if you can just tell me what it's like in the courtroom when all these little hushed conversations are happening and we can't, if you're watching on the streaming, you don't hear a word.
It's not typical in my experience. This is a high-tension case. This is a high-impact case. And if either of the legal teams, any of those lawyers, feels that they need to bring something up with the attorney sidebar or ask a question or raise an issue, they're not going to lose it. They're going to take it. They're going to take that chance.
Got it.
So expect more sidebars.
Oh, good.
And to your question, JC and Glenn, it is so crowded in that room, right? There are so many attorneys. Karen and herself are 8, and then there are more at the Commonwealth, and then today it was packed with all the friends and family, so that's 20. All the journalists are in there, and the lawyers are sitting in these big office chairs, not little chairs, but which, as they should, because they have to be comfortable. So when there's a sidebar, like David Yannetti has to get up and get out of the way, and Karen's going up, and then Jackson has to come.
Crowded
and
line.
It's like I said, it was like being on the highway trying to take that, when you're on 95 and you need to take or 93 to take the exit to 95.
Wait for the other car to move.
We all yield in, and as soon as that happens, the jury jumps up because the judge has given them permission to stretch and stand during a sidebar, and there's some big people on the jury, some big and tall guys. So as soon as someone says sidebar, they jump up and stand up because they have been so cramped. So there's like 60 people in this tiny room with big office furniture. So whatever you're seeing on the broadcast does not relate how completely cramped we all are.
I didn't even think of how it benefits the jury to get up and stretch.
Yes.
That I had discounted.
I got to do that at home when I'm watching.
It's not what you'd see in a movie
No.
set. A movie set is a very large set. It's very wide open. People walk around back and forth. This is a very cramped environment, and it creates an atmosphere.
I'm sure.
Creates an atmosphere like, can you...
Yes.
Something like that. It's very small.
All right, let's get quickly to a viewer question. Ian Whiffen was on the stand. He brought a lot of data with him, and there was a lot for the jurors to process. So let's go to this viewer question, which really does touch on that point. Will the jury have copies of the phone timelines to take back to the jury room with them? Bill, can you handle that one with us? And maybe even generally, what are they allowed to use during deliberations?
They are allowed to review any evidence that was admitted into evidence into the docket.
So that would include the timelines?
Yes, exactly. And they're going to be critical for them to review in detail. So they will ask for them and they will get them. They can't ask for evidence that wasn't admitted into the record, but they can and they will ask for all evidence that was admitted into the record, including the phone logs.
Of course, they have to understand it. I mean, there's a lot of data on those pieces of paper, so... are they doing a good enough job so if I presented you with that you could remember and understand what I'm presenting?
Well, I'll say, JC, that there are more jurors, percentage-wise, taking notes in this case than there were the first time. There are at least 5 jurors who are note takers. Like, you can tell when you look at them. They get in, they get their notebook open, and they are writing almost the entire time, not just when something strikes them. One of them is actually, I can see, folding and going back and making a notation and going back and forth. We know from our conversations with Ronald, the juror, that the people who had the notes were the most helpful in the deliberations. So in this kind of trial, those note takers are, if they make it to the final 12, they're going to be essential to the deliberation process.
Yeah. It's a long process. It's going to take weeks. And when they get to the end, those notes are going to be valuable.
Yep.
I would need a notebook full of notes.
Absolutely.
Although I did hear they have to get rid of it at the end, right? They're not allowed to keep those notebooks.
Not at the end.
Not at the end. I was just curious. It's a lot of work.
Yeah. It would help write the book.
Yes, exactly. Listen, we're trying to answer your questions all the time, so please keep sending them our way. The email is on your screen, canton.confidential@nbcuni.com. We'll answer as many questions as we can.
And remember to join us here on Canton Confidential, the Karen Read murder trial. Every weeknight at 7, we'll have a full recap of the latest developments from court as well as legal analysis. Coming up tomorrow, we expect to see Jen McCabe back on the stand. And plus, episodes will be streaming on Peacock. You're watching Canton Confidential, the Karen Read murder trial.